now I'm going to introduce our esteemed keynote speaker. Catherine Lhamon is the Assistant Secretary for the Office of Civil Rights at the U.S. Department of Education. She was formerly the chair of the U.S. Commission on Civil Rights, and she previously litigated cases at the National Center for Youth Law and was Director of Impact Litigation at Public Counsel, the nation's largest pro bono law firm. She practiced for a decade at the ACLU of Southern California, ultimately as Assistant Legal Director. Earlier in her career, Lhamon was a teaching fellow and supervising attorney in the appellate litigation program at Georgetown University Law Center after clerking for the Honorable William A. Norris on the United States Court of Appeals for the Ninth Circuit. In 2016, the National Action Network honored Lhamon with their Action and Authority Award. In 2015, Yale Law School named Lhamon their Gruber Distinguished Lecturer. In 2004, California Lawyer magazine named Lhamon Attorney of the Year for Civil Rights. She received her JD from Yale Law School, where she was the outstanding women law graduate, and she graduated summa cum laude from Amherst College. Please join me in warmly welcoming Assistant Secretary Catherine Lhamon.
Well, thank you, Kimberly. I could not be more delighted to be celebrating 6 decades of Title VI with all of you and to be thinking together with you about a path forward for the next many decades. And I just want to recognize and join you in your deep commitment to making equal opportunity actually equal for every child in school. It's very exciting to think about that, and I think it's not aspirational. So I am excited that we are together going to make it real. As we know, we as a nation have infrequently and inconsistently achieved the Title VI guarantee that no person, that's the statutory guarantee, shall experience discrimination based on race, color, or national origin at school. And that lack of frequency or consistency was a key driver for the passage of Title VI in the first place. We know here in Virginia the massive resistance to integration in southern states, including this one, in response to the Brown versus Board of Education decision 10 years earlier, had laid an ugly foundation for the need for a federal law that would guarantee what President Kennedy had called the simple justice that no federal funds be spent to discriminate. But even after passage of that beautiful law, regular resistance otherwise perpetuated and still perpetuates throughout the country through various means. So we've lived a very long history of unequal schooling that persists now, punctuated periodically with beacons of hope and confirmation that that inequality is not actually inevitable. So I'm proud that my office acted aggressively in the first years after Congress created us to enforce the 1964 Civil Rights Act in schools. We withheld federal funds from some 200 southern school districts that refused even to sign an assurance that they would not discriminate on the basis of race. And we aggressively enforced the school desegregation obligations that had, without federal enforcement, been slow in coming in the first years following Brown. Following that robust enforcement, school districts generally fell in line to make those required assurances and promising at least to offer non-discriminatory education. And that led to an apex in school integration nationally by the mid-1970s. And then followed a retrenchment with U.S. Supreme Court decisions that narrowed available desegregation remedies and federal agency enforcement decisions, including from mine, that limited any path to remedy in those jurisdictions for all time following. It is enormously frustrating to me that for more years than I have been alive, this great nation has required federal century to make meaningful our national aspiration to provide school conditions that we know are essential and fair. And it is equally frustrating to me to realize that the very first desegregation agreements that my office was created to enforce involved many of the same issues that we see in schools today. Ending racially discriminatory school discipline, ensuring access to high-rigor coursework for all students in all schools, regardless and unlimited by race, ensuring that school resources, trained teachers, decent school facilities, access to instructional materials are available to all on an equal basis, and promoting racially inclusive environments without harassment based on race. Thomas Jefferson is famous for having said that the price of liberty is eternal vigilance. And we know, and our history has confirmed again and again and again, that the struggle to offer actually equal schooling on a non-discriminatory basis requires just that vigilance. And so it can be tempting to conclude that the gains that we have made over 6 decades since Congress created the Title VI guarantee have not been real or do not amount to significant legacy. I hope, though, that the lessons of history about the persisting impulse to discriminate and the Sisyphean challenge for those among us who champion equality also seeds bases for optimism. I know you all have spent today considering the impact of Title VI and the ongoing challenge and the experience of race, color, and national origin discrimination today. And I want to highlight for you what keeps me in this work as we close out your conversations today. So I'm going to start with some case stories. Last spring, we resolved an investigation of a Utah school district where the facts as we found them were truly appalling. District records documented more than 180 complaints to the district about discrimination, about students harassing other students based on race and other protected identity characteristics at three schools in the district during 2 school years that we were looking at. The harassment included ugly slurs that are a panoply of hate. They included calling students the N-word, asking for N-word passes, calling students monkey, acting like a monkey toward students who are Black, making racially and ethnically offensive jokes, including about bringing back slavery, telling Asian students to, quote, go eat cat, and mocking a student's, quote, Chinese eyes. Physically assaulting students, threatening, and this is a quote, to kill all the Jews, and posting swastikas, calling Latino students illegal and telling them they are good at cleaning, because I guess that's what you're going to do when you grow up. That was a quote also. The district did take some responsive actions, as one would hope, including training staff and sending notes home to parents. But ultimately, the district's response to repeated harassment of Black, Asian, Jewish students did not meet the district's federal civil rights obligations. In particular, the district repeatedly failed to evaluate allegations of race-based and anti-Semitic harassment and to take effective steps to end hostile environments based on race and anti-Semitic harassment that the district confirmed. So we have a resolution agreement with them. That's why I'm telling you about this. They are under federal monitoring, which I'm very excited about, and I'm enjoying what that monitoring has been so far since last spring. But in addition to the many important commitments that the district made in their resolution agreement with us, the good news is that the day we resolved the case, the district posted information on its website about what it would do better going forward. The district said, this is a quote, "These incidents do not reflect the values of this community." This is my side editorial, I hope not. And back to the district's quote, "and the expectations of the schools or the school district. This important work begins immediately and will continue over the next several years. The district is wholeheartedly committed to creating and maintaining a safe and welcoming environment for all students, free from harassment and discrimination." That's what the district said when we resolved. That district has embraced its glaring need for change and continues to post regular updates on its website and superintendent messages to the school community about the district's responsive steps to build more equal opportunity, consistent with Title VI, among other laws that we enforce for its students. I hate that the kids in the district had lived what they had lived in the district for so long before the resolution agreement. And I hold fast to hope for the to-be-transformed opportunity for kids there now. And to be clear, of course, we are not relying on hope. We will be there every step of the way to ensure that that district, in fact, transforms and fulfills the Title VI and Title IX and Section 504 non-discrimination guarantee for each and every child. The district's embrace of its obligations for change are inspiring to me, and they do confirm for me that change is possible, even when it requires a federal backstop against harm to begin it. I do often need that reminder and inspiration while working with recalcitrant districts and colleges and universities on what seem like very basic non-discrimination principles. So I'm going to tell you another example about why I needed that hope in a district that I'm looking forward to change for. Just a few weeks ago, we resolved an investigation of a school district in Pennsylvania that had received repeated reports over a 10-month period that spanned 2 school years of significant race-based harassment in a school that had only 1.4% Black students. The notice to the district included a Black student reporting to his principal and other school staff about an ugly video circulating on social media among students that used race-based slurs. This student, this child, said to his principal, this is his quote, what he wrote, "I just wanted to share with you a little piece of the disturbing racism that goes on in the district very often, that goes unnoticed. Things like this affect me often. This video just lets you see a little part of what it is like for a Black person in our majority white school." In response to that child's quote, the principal told that child that the district conducted an investigation, but did not provide any more information to the student or solicit from that child any more information about what he was experiencing in his school environment. Our investigation confirmed that over and over and over the 10 months, the school district chose to ignore and to minimize reports of race-based harm that it received. After the district received reports of racially offensive posting on social media and later a group chat that involved promoting the hanging of Black people and setting Black people on fire, the district referred the matters to the police, which was a good step, but did not otherwise respond at all to those reports. It did not consider or redress their effects on students' access to education. And later, during the School Spirit Week in October, the district highlighted a theme day that it called America Monday, which, perhaps unsurprisingly, led to some students who had participated in prior racial harassment that the district had declined to address, to attending school in Confederate flag attire to commemorate that America Monday theme. And when parents and students and community members erupted in distress to complain to the district about the Confederate flag wearing, the district's response was to issue a press release saying that the kids had not known what the Confederate flag symbolized, which was demonstrably untrue. We don't even have to just suspect that it was untrue. It was demonstrably untrue because the district had also received reports of social media images of those kids at school in their Confederate flag attire with a caption titled "Cool Kids Club," spelled with 3 Ks, to refer to the Ku Klux Klan. And these same kids showed up later, again, wearing Confederate flag attire and a hat displaying the message, "To kiss my rebel ass." We found this district violated its Title VI obligations to assess whether a racially hostile environment existed that limits or denies access to education for its students, and that district, too, is subject to federal monitoring, about which I'm very excited, and it has not posted on its website yet its enthusiasm for what it will do going forward, but we'll get there. I have every confidence that we will. I would like to tell you that that case is an outlier, but it really is not, among the many, many, many other cases we investigate related to harassment based on race, color, and national origin, all of which Title VI protects against. I'm just going to tell you one other reason why we need federal backstop against harm, why we need to remember that all of us have to throw ourselves at the problem of ensuring that our kids are okay at school. Because amid all of the conversation about what is too woke, what is happening at schools, whether we have overrun our education endeavor in schools, we ask our kids to try to learn math in these contexts at school. And it is not what our federal law guarantees. In a California district for several months, peers repeatedly mocked and taunted a 13-year-old middle school student, using slurs and epithets on the basis of that student's race, color, and national origin. Sometimes I think people think that those are throwaways and they might be synonyms for each other. Here's why we know for this kid that they are not. The harassing peers called this child Blackie, spear thrower, monkey, gorilla, and the N-word. They taunted her dark skin, and they told her unsolicited that they would only date her if she were light-skinned. They mocked her for coming to this country from a country in Africa, showing her pictures of malnourished children in Africa and asking whether the depicted children were her relatives. As a result of this repeated harassment, this targeted student hid in the restroom to avoid classes with students who taunted her, missed class frequently because of the harassment, received failing grades that were not later replicated when she moved to a school where the harassment did not persist, experienced suicidal ideation, and felt physically ill, all of which she and her family reported to her school. And although this district received repeated notice of this harassing conduct, the district did not respond for 3 months, other than one school leader talking to one of the harassing peers, which evidence suggests led to retaliatory harassment. After 3 months of notice, the district finally offered to change some of the students' classes to separate her from harassing peers. But then the district did not address the harassment that persisted thereafter. So we determined there was a Title VI violation, the student's peers, harassment, targeted her, creating a hostile environment based on race, color, and national origins, that the peers retaliated against her for reporting the harassment, and that the district failed to respond in a reasonable, timely, and effective manner. Good news there is, in addition to a very substantial settlement with that student and the family from the district, it has also committed to holding restored meetings with students, parents, and community members to train on racial harassment, student and parent rights, and the district's obligation to respond consistent with Title VI, and to issue an anti-harassment statement and to report to me about all of the ways it responds to harassment moving forward for a period of years. We'll just say harassment is very far from the only type of race discrimination we still see in schools, and P-12 schools are very far from the only places where we see that discrimination too. Last spring, we resolved an investigation of a university that treated students of color differently than their white peers with respect to access to courses and enrollment. So just the basic in going to college, that it was just rougher if you were a student of color than a white student in the school. And last year, we resolved an investigation of another university that confirmed that a graduate student at the university suffered a physical attack and repeated verbal abuse from an instructor based on the instructor's prejudiced views about Asian students. And the student's university took the incorrect position that it lacked jurisdiction to investigate because the alleged discrimination occurred in a clinical internship program, which is just not correct. Just say that again in case there was any lack of clarity about it. So the university had declined to respond until my office got involved. And a few weeks ago, we resolved an investigation of whether Black students were treated differently and more harshly than white students with respect to school discipline. Unsurprisingly, because I'm telling you about it, they had been. And what we saw was persistent and statistically significant disparities in the discipline of Black students compared to their white peers across all of the 10 years we reviewed in this district. In particular, Black students were treated differently and worse at the referral and sanctioning stages of the discipline process. And to give you both data and an example of why that was so harmful for kids, in one of the school years we investigated, 57.6% of Black students were referred at least once in that district, and that compared to 25.8% of white students. And in case you're curious, in this district, Black and white student enrollment was about equal. White students were 39% of the students in the district, and Black students were 37%. And an example of how the students, when we looked underneath the data at the actual case files, how the kids were treated, an example of how Black students were treated differently and worse than white students. A Black middle schooler in one of the years received a quarter-day in-school suspension for being, quote, continually on cell phone after warnings and redirection, which I share as a parent, I find frustrating. But that was that student's first discipline referral for that school year. Same school year, a white middle schooler did not receive any suspension at all, but had a parent conference. After this student had been told several times not to play loud music on their phone, and then had ignored the assistant when they told him they were going to report the student to the administrator, before the student finally threatened the staff member that snitches get stitches, in what was this student's third discipline referral of the school year. So materially different consequence for white students and black students, and not even particularly comparable behavior at school. Here, this district is, of course, also subject to federal monitoring. I'm excited that the resolution terms include involving parents and community members in working with the district on what its policy should be regarding school discipline, and that district will annually report to my office about data and discipline practices, and it will identify staff who overuse discipline and students who are repeatedly subject to discipline, so that the district, as part of its commitments, also will report to us about whether those students need additional supports. I flag this case in particular for you, not only because it is heartbreaking, which it is, and because it's long past time for us to do better by kids in school, but also because it reflects the power of data, which I heard you all talking about in the last panel also. I say all of us can access the federal civil rights data collection data that we access. As I hope you know, we have been collecting civil rights data from every school in the country most of the years since 1968 forward. And these data persistently reflect stunning disparities in access to equal educational opportunity by race, as well as sex, disability, and English learner status. The discipline data in the Kentucky school district I was just talking about are consistent with the data we see over and over all across the country. In the most recent publicly available civil rights data collection from the nation's schools, the data reflect that black boys were nearly 2 times more likely than white boys to receive an out-of-school suspension or an expulsion. And those disparities translate across opportunities we measure in the civil rights data collection. We know, for example, that in the most recent data, public high schools where students of color are 75% or more of students generally offer fewer mathematics, science, computer science courses than schools where students of color are 25% or fewer of the enrollment. And to make that really concrete, here is the state of school offerings and course taking for the nation's black children compared to their peers. First, only approximately 48% of the nation's high schools offer calculus at all to anyone. I find that jaw-dropping, that more than half of our nation's high schools do not offer calculus, period. And black students, who constitute 15% of all high school enrollment, are only 7% of high school students enrolled in calculus, and 6% of students enrolled in AP Math, 8% of students enrolled in AP Science, and 10% of students enrolled in AP Computer Science. We are underserving our kids, period. We know that. The data tell us that. And the case resolution examples I've shared, among so many others, and some schools' responses to them, do reflect that equal opportunity at school is possible and achievable. And they also confirm the painful truth that discrimination proliferates without meaningful enforcement of laws to the contrary. So we need laws directed specifically at eradicating discrimination, targeting the simple justice that our federal government and the taxes that sustain it, to which all of us contribute, must not contribute to discrimination. And we need vigilant, serious enforcement to clarify for anyone who does not know what discriminatory harm looks like. I so much want all of you who are present to continue your important research and your advocacy work to realize that possibility as well. What we know is that work, researching what is possible, advocating for what is necessary, is an important element for ensuring that federal civil rights guarantees are the actual experience of affected people. One constant in the cases I've described is leadership that refuses to accept an expectation that kids can't succeed. My favorite is when that leadership comes from the school community itself. But I am okay with providing external leadership through federal enforcement where needed. So another constant is hope. Where we provide equal opportunity for kids, we do it because we believe it is possible. We do it because we have hope. So the lesson here is to do what we say in the Black folk tradition: make a way out of no way. Remember that it is possible. And remember that if we don't realize that possibility, the alternative is so much worse. We, in the Office for Civil Rights today, are actively enforcing to make meaningful Congress promise that no person will experience discrimination on the basis of race, color, national origin in schools that the department funds. Remember what I mentioned at the beginning about OCR in our early days withholding federal funds from 200 school districts that refused to sign an assurance of the Title VI compliance. Last fiscal year, we resolved 3,707 cases raising Title VI issues. I commit to you that I and the nearly 600 people I lead in the Office for Civil Rights will continue our vigilance for democracy, and I look forward to ongoing work in parallel with each of you to make Congress promised rights real for every student. I hope you, like I, will keep the faith every day, no matter what obstacles we find in front of us. And I look forward to the conversation.
All right, so I'm just going to share a few questions, and then I know we're going to end promptly at 1:30. So let's talk about, those were very compelling stories about what's happening in the enforcement effort. I'm interested in, we know that obviously the openly clear, disparate treatment is racism and white supremacy at work. But what are the other causes of Title VI violations? Is it a lack of knowledge of what's required? Is it a lack of attention to the data? Is there some other cause that we should be aware of that school districts should be focused on? Like, what's driving, 60 years later, we're still violating the key principles of a federal civil rights law?
I'm going to answer that several ways. One, we had insufficient political will, period. That's where we are. We've had 6 decades of a guarantee that that there's simple justice and no person will experience discrimination. And every year, like so many people do. We know that. And we are insufficiently committed to correcting that in schools and across the country. You ask, why? Why does that happen? I say, as the chief civil rights enforcer in the nation's schools, I don't really care. Where you hurt a kid, we will fix it, period. And whatever your reason is, we will still get there. The law guarantees that it cannot happen, period. But on the, I'm curious, why does it happen? I don't know any educator who went into education because the educator wanted to hurt kids. I think typically people have a lot of things on their mind, a lot of things they're trying to do, not really thinking about it, and it's hard to fix it. But I think when you decide to become an educator, you decide to stand in front of a classroom and to help people become who they dream about being. You should be treating every mother's baby like that baby is a precious jewel who has dreams that should be succeeded. And I don't understand why I have to have the same conversation over and over and over again with school communities, and why I hear so often with school council, from school leaders, from college and university leaders and council, that we didn't know. This is new to us. We're not really sure. These are not new principles. I'm going to say they're really, really not. And the fundamentals of assaulting a kid because of who the kid is, because of a stereotype about that person, that's bad, right? It doesn't really require a lot of parsing on that. So it gets back to insufficient political will, right? It gets back to people's speed if they don't see a police officer, right? People break what we think are little laws because we think we won't get caught, or we think the consequence won't be that significant. I think that's an ugly truth, but it is the truth. That's what Thomas Jefferson meant when he said that the price of liberty is eternal vigilance. We have to be eternally vigilant. We have to be eternally present to be clear. We will find you. We will correct it. it will be consequential. It will be unpleasant and embarrassing. So I think that is our reality, as sad as it is.
Thank you for that. So talk with me about some of the struggles that OCR has. So one of the things that came up earlier was the length of time it takes to get a resolution from OCR and action when a complaint is filed. So this came up in an earlier panel. So I'm interested in, like, what do you feel like is going well, and where do you feel like there's room for improvement at OCR?
I am pleading with Congress. I have been pleading with Congress to appropriate additional funds for OCR. And I want to really make clear why that matters. I mean, I heard in the last panel that funding is necessary and not sufficient, and I super agree with that. And I'll talk about all the things that we're doing to maximize the efficient use of our funds. But when I came to OCR 11 years ago for the first time, we were receiving not quite 10,000 cases a year in complaints that came in. The fiscal year that just ended on September 30th, we received nearly 23,000 complaints. I mean, we're well above where we were when I started, and we don't have more people. So, unless Congress can appropriate additional funds, we cannot get there faster. And in addition to running the Office for Civil Rights, which is my favorite job on the planet, I also have 2 kids, and I know that I don't want them to miss a minute of learning. I'm not okay with a minute of harm to them in school. And I approach our work, the staff I work with approach our work with that same core mama bear feeling that everybody's kid needs to be okay. So I'm sick every day about the cases we don't get to. I'm sick every day about the relief that we can't secure. And we are looking for ways to be more efficient. We instituted a new process where people can ask us to mediate, and we can move those cases more quickly. Last fiscal year, we moved in excess of 600 cases through mediation to get relatively speedy results for the families who came to us that way. But we're not using our expertise in our civil rights enforcement. We also are at that period where we've been very aggressive, we are very loud about what we think needs to be happening in schools. So we have a lot of schools now saying to us, well, are you still going to be there in a few months? I am planning still to be here, just to be clear. but also, yes, the law is what it is. Yes, you still have to comply. Yes, you still have to do right by kids, and we will check. And I think there's this myth, because the rhetoric in the last administration was so ugly about civil rights, and there was so much rescission of policies that I deeply loved and deeply believed in, that the office wouldn't seriously still enforce. But I've looked at those cases. They weren't issuing press releases about it, but they were enforcing these core principles against harassment, against race discrimination. We will find you still. And so the obligation still exists, and we need to use our voice. We need to use our lever to be really clear about that. And I think it's incumbent on us to do every bit as much as we can every day that we can, which we are trying to do.
Yeah, and I think that's just such an important point. And I felt this when I worked at the Department of Education, which is that there's so much more continuity in civil rights than there is disagreement, right? There are core principles that you can't discriminate. And both parties do enforce that. They might have differences on certain topics, but there are core principles that are enforced consistently. And I think that's something that, in this partisan era, people don't talk about. But
It could have been more consistent also, but yes.
yes, no, I'm not saying that there aren't some disagreements and that there's not room for improvement on either side. It's just, I think it's overlooked that there's a lot more consistency than there are agreements,
Right.
disagreements. Okay, so last question, and then we'll wrap up for today. So let's talk about the disparate impact regulation that came up, and we know it's being litigated. It's in other areas and often under attack. Can you tell us about how OCR is thinking about disparate impact and sort of looking ahead, ways for it to continue to be utilized?
I mean, until we lose it, we use it. So, for me, we use every tool that we have whenever it's necessary and in every case. And we are shoring up the basis for it, why it's important, why it matters. I hope that I don't get too weedy on this, that there's basically 2 theories of race discrimination that we have jurisdiction to enforce against. One is the intentional discrimination theory, and the other is unjustified racially disparate impact. The United States Supreme Court has said that private litigants can't enforce the racially disparate impact theory, so it's left only to the federal government to enforce it. And there's long-standing criticism that it's not really necessary, but here's how I know that it is. Here's the kinds of discrimination that can occur in a school that you can't get at with an intentional discrimination framework. Just to give an example, several years ago, we resolved a case at the California School District where Black kids, students of color, were persistently unlikely to be in gifted and talented education courses in the district. And we investigated what was happening with the district, and the district had actually taken lots of affirmative steps to increase equity in their gifted and talented education programming. So it certainly wasn't intentional. They actually had been intentional about making sure that students of color were a participant, and yet the impulse to discrimination is strong. So they were relying on teacher referrals, and teachers weren't referring Black kids very much. They just hadn't crossed that barrier. So we found a disparate impact violation for this district because they had not intended to discriminate, and still they were not offering racially equal opportunity to students in their district. And as the resolution terms was not to kick white kids out, but to expand the pie so that there would be anybody with a C or better average who wanted to take the courses could take the courses, and the district would advertise to everybody in the community that it's available. And then they also did affirmative support for students to learn, executive function skills, to learn homework skills, to learn test-taking skills, so that the kids who had been at the C average were able to be as successful as their kids who had been at the A average, and they were. What we saw when they added to who could be in the program, those kids succeeded. Those kids believed in themselves. Those kids did well. They could do it. So it's an amazing result, and it's an amazing proof point for why it matters to actually communicate that we believe in everybody, and that there's not a pie that's so small that we have to kick somebody out. But we only got there. The only way we could get there in this district was through use of the disparate impact frame, because they had not intended to discriminate. So, I think it's a really important tool. It's one of my favorite reasons for being in the federal government, because I have access to that tool, and I didn't when I was a private litigant, and I enjoy using it while we still have it.
Thank you so much for being with us.